We're about to dive into a legal case that revolves around a really critical question. Where does the protection of the law actually end? It's a story about marriage, divorce, and, believe it or not, how the entire outcome hinged on something as small as grammar. All right, let's just jump right in. Picture this scenario. A marriage is over, the divorce is finalized, and a woman wants to use the Domestic Violence Act to address abuse that happened during the marriage. So can she do it? You'd think the answer would be a simple yes, right? Well, you might be surprised. In a landmark ruling, the High Court's answer was a firm no. And the reason why had nothing to do with the evidence of abuse. Instead, it all boiled down to a few specific words in the law, and more importantly, the tense they were written in. Let's break down how this incredible decision came about. So this all starts with one family and one case, Amit Agarwal versus Sanjay Aggarwal. Now, to really get why the court ruled the way it did, we have to look at the human story that brought them there in the first place. Ritu and Amit Agarwal got married back in 2003, but things went south and Ritu eventually filed a police report, an FIR, alleging assault and demands for dowry. Fast forward 10 years to 2014, and Amit gets an ex parte divorce. Now, that just means the other person, in this case Ritu, wasn't present for the proceedings. But here's the crucial detail. It was after the marriage was legally over that Ritu's brother filed a complaint on her behalf under the Domestic Violence Act, and that one move kicked off a huge legal showdown. Okay, so the case goes to the Punjab and Haryana High Court, and the judges are looking at two totally opposite interpretations of what this law is even for. On one side, you have the husband. His argument is pretty straightforward. Look, we're divorced, there is no domestic relationship anymore, so you can't use the Domestic Violence Act. This is just harassment. But on the other side, the wife's argument is, hey, the law says anyone can file a complaint for an abused woman. A divorce shouldn't just wipe the slate clean and erase my right to seek justice for what happened. So, how do you solve this? Well, the court basically had to put on its grammar police hat. Seriously. It went on this deep dive, analyzing the specific words and tenses used by the lawmakers. First, they looked at the definition of an aggrieved person. The law says it's any woman who is or has been in a domestic relationship. Now, that phrase, has been, really sounds like it should cover past relationships, doesn't it? But the court looked even closer. The court zoomed right in on that wording. Is or has been. Notice it doesn't say a woman who was in a relationship. That little distinction, well, it turned out to be everything. Here's how they saw it. The use of the present tense is suggests that the domestic relationship has to be present and alive at the time the complaint is filed. So while she has been in the relationship, some form of it must still exist. And that was just the first clue. The court kept digging, and what do you know? They found the exact same pattern when they looked at the definition of a domestic relationship. And again, it all came down to grammar. And there it is again. The law says when they are related by marriage, not when they were related. Another present tense verb. For the court, this was starting to look less like a coincidence and more like a clear pattern. So, putting the pieces together, the court saw a clear intent. Both of these key definitions use the present tense. The takeaway? The lawmakers wanted this act to apply only when there is a subsisting, a currently existing relationship. And in the court's view, a divorce absolutely severs that tie. So, with all this grammatical detective work done, the court was finally ready to deliver its verdict. And it was crystal clear. And that's it, right there. A powerful, direct ruling. Once that divorce decree is final, the domestic relationship is legally over. And because it's over, a complaint under the Domestic Violence Act can no longer be filed. A definite line in the sand had been drawn. So let's just quickly recap the court's logic. 1, to file a complaint, the domestic relationship has to be active. 2, this whole idea is based on that present tense language in the law. 3, a valid divorce decree, even an ex parte one, officially ends that relationship. And 4, trying to pursue a case after that could be seen as an abuse of the process of the court. That's why the complaint was thrown out. Now, this decision wasn't just about one couple. The Amit Agarwal case sent massive ripples through the legal system, setting a powerful precedent all across the country. Pretty soon, this interpretation became the new standard. Other high courts, from Delhi to Bombay to Kerala, started handing down similar rulings. They all echoed the same idea. The protections under the Act, like the right to live in the shared home, end when the divorce is finalized. The precedent was well and truly set. So, what's the big picture here? The courts have essentially said the Domestic Violence Act is meant to be a shield, not a sword. It's there to offer urgent, immediate help to women who are currently in a violent situation, not to be a tool for going back and litigating the past after a relationship has legally ended. And this leaves us with a really tough question. This ruling tries to stop a protective law from being misused after the fact. But does it also close a door for real victims who are trying to get justice for trauma they've already endured? The Agarwal case drew a very sharp line based on the letter of the law, but the debate over where that line should be drawn, well, that continues.